In the case of Attorney General versus Michael Kabaziguruka, the Supreme Court judges ruled that military courts should no longer try civilians. In their judgment, led by Chief Justice Alphonse Owinidolo, the justices noted that military courts may not always ensure fair trials, as their judges are often not trained legal professionals.
By finding that sections 2, now 179, now 177, and 119(1)H, now 1171H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offences within the General Court Martial and other military courts tribunals.
Other guarantees of justice and fairness in criminal proceedings are the right to a fair trial and the right to a fair hearing as stipulated under Article 28(1) of the said Constitution.
Senior lawyers Abdu Katuntu and Mukasa Mbidde have hailed the ruling as a positive development for civilian justice.
I think this is a fundamental decision taken by the Supreme Court of the land, the highest court in the land. It has redefined what we call military justice. That military justice or martial law is certainly for soldiers. But even then, it has advised reforms. It has advised reforms such that we amend the UPDF Act and bring it into conformity with the constitutional commands. So the court has been exactly succinct on the rights of any person available for trial, be it in the court-martial court or any other court of law. And it has guided that a court-martial that is established for purposes of adjudication, let it be established as one of the departments of the High Court of Uganda. It must definitely be manned or womaned by competent persons. And that is the only way justice can be seen by the reasonable persons.
The lawyers, who are also members of parliament, urged the military to respect the Supreme Court's recommendations, including appointing trained legal professionals as judges and amending the UPDF Act.
So we need a court established that is professional in nature, that has the competence to adjudicate by evaluation of evidence and therefore giving judgments that are not the subject of partiality. So the court shall be established, but let it be a department. Like we have got an international criminal law division of the High Court. It is there, which definitely would try cases that ideally would be tried by the International Criminal Court. But it is a division. It's not only good for civilians, but also good for the soldiers. The court was so much concerned, especially the decision of the Chief Justice, about the competence of the people who administer the justice. And that does not relate only civilians, but also for soldiers or servicemen who are appearing before them. So we will need qualification for somebody to preside over that court. Not judge advocates whose advice really may be taken or may not be taken by the court. So members of the court martial should actually be people qualified in the administration of justice, even for soldiers themselves.
The UPDF Act currently allows civilians who commit offenses alongside military personnel to be tried in military courts. However, the Supreme Court ruling now mandates an amendment to the provision. Philip Aguta for UBC News in Kampala.